be here long enough.
It was
literally 2 minutes.
It was.
We need to go home right after this class.
You're going to run out, is that the plan? Your moment is here. Oh, ouch.
See, that right there, that's trauma for filtering
You're not going to get through it. No, they're all gang together, don't worry about it.
You need
No, don't. Don't need anything yet. Section 15, our last class for the semester, but I want to remind you and people online that Supreme Court is here on Thursday. You should attend. I want to talk to students about future pro bono activities and really try to engage you. I don't think that you have an opportunity that often to meet a justice of the Supreme Court and to hear their views on certain things. And they think it's really important that you attend, and I do too, not that I'm minimizing it, but so that you can hear about the various activities that they are aware of as well, and hear about some of the things both from your colleagues here as well as alumni with respect to different clinical externships and volunteer opportunities that you might want to think about before you leave, or even as you start to make your plans for leaving, what types of activities you might want to engage in. And certainly it's not just about doing good from your standpoint, but it also gives you an opportunity to get some practical experience as well, and that's important in your development as a lawyer as well. So I'd give that some thought as well. But please make sure that you spend some time on Thursday night from 4 to 6. It'll be in room 208 across the way. We're going to talk today about post-judgment remedies. And what that means is, well, now we've got our judgment, or we're getting our judgment, how the hell do you get paid? And again, this process should really start at the outset of the case. You need to make an assessment whether there's money at the end of the road here, or maybe you shouldn't be taking the case. And there are times where you've got a great case on liability, but there may be no assets that are going to be available to satisfy any potential judgment, which means you don't have much of a claim at all then. Go ahead.
There was an attorney I was working for. It was his firm that specializes in creditors' rights. And oftentimes we get clients into the office who would say that, listen, I don't care if the debtor is solvent or insolvent. I want that judgment so 5 or 6, 7, 10 years down the road, he has money somehow. I want to be able to collect on that. So it's not really.
They're paying you hourly to do that, or are they paying you on a contingent basis?
Say again?
Are they paying you on an hourly basis to get that judgment, or a contingent basis?
Well, my understanding was that they just paid, for us to get the judgment, it was like a flat fee or something, like $1,000 or something like that.
Well, what do you mean it's both? If someone's going to pay.
There are some clients paid it hourly, some are contingent.
Okay, well let me just explain why it will make a difference. If you take a claim on a straight contingent basis, what that means is that you will get a percentage of the recovery. Usually it's a third. Sometimes it's as high as 40. You've heard people charge 50. Sometimes it could be 25%. But the percentage, as a general matter, is around a third. But what that means is that you've got to win, and you've got to collect something in order to get a third. A third of zero is still zero. And so if you're working solely on a contingent basis, you might have a claim that damages will come to $1 million, and clearly this is not fabricated to get there, but I've got $1 million claim. But if the people have no assets and no likelihood of assets in the future, then you have a claim that probably is worth zero. And so if you're working on a straight contingent, again, a third of zero is zero. If, on the other hand, they want to pay you for your time and efforts, and so they're paying you whatever the number is, but just to make the math easy, a couple $100 an hour to pursue the case through the litigation and obtain a judgment, and then they can take that paper and wait, because a judgment will be good for 20 years. Well, that's a different story if they're paying on an hourly basis to recover the judgment because you're getting paid for your efforts. But the problem comes in when you're not getting paid for your efforts and you're only based on a percentage of recovery. Then you really need, at the outset, and I also think, though, even on an hourly basis, you need to have that conversation with the client at the outset, because, you know, if I paid you 10 grand to get that judgment, and now you tell me there's no money, the claim is, in essence, I'm going to have to sit for years on this judgment to recover. I really think that's a conversation you should have told me at the outset. So I still think this whole notion of investigating possible recoveries and the like, that happens at the outset. You know, I think I mentioned it one time before, when that whole, what is it, White Snake down in Rhode Island, the concert with the horrible fire at the club.
Great White.
Great White.
Yeah.
When I first heard the start of that suit, then it started, they talked about, they even sued Budweiser because there was Bud bottles in the bar. And I'm thinking, come on, that's just crazy. But if you saw the list of people that ultimately were collected in that suit, there were some relatively far-fetched theories of recovery. Okay, even the radio station that took the advertising for the concert was sued. But the reason we do that at the outset is that I need to make sure I've got as many viable candidates to satisfy that judgment now than get to the end of the road and find out I've got one corporation, that corporation appears to have been looted or whatever, for whatever reason, the assets are gone and there's no money left. And so you want to do your analysis and investigation at the outset and think about are there ways to preserve those assets at the outset as well.
So essentially you do a search for the deepest pockets. I mean, you want to cover your whole basis to make sure that you can get the assets from all of those corporations or individuals just to ensure a good recovery for your client, correct?
Yeah, but I don't want to say it's just the deepest pockets, obviously, because you have to make sure that you have a legitimate claim against that entity as well. And so it's not just deepest, it's also, do I have the right parties? I was looking at one yesterday, it took really over an hour or so to figure out what the right corporate structure was, because it's a large multinational corporation with subsidiaries, and one of the companies is public, but one isn't. And to try and find just simple principal place of business and state of incorporation and of a major multinational company really took over an hour till I was comfortable that I had principal place of business and state of incorporation. And I believe now, in thinking it through, I'm probably likely to name the three corporations because there's interplay between them, and oftentimes when it's done effectively, there's a little bit of a shell game. So that you have to make sure you've got the right parties there, so that 2, 3, 4 years down the road, they're not saying, "Oh, you sued the wrong entity here." I've told some of you before, I sued on behalf of a couple clients who were hurt down in Disney World at one of the hotels there, not at Disney, but near Disney, what's Pleasure Island there, whatever that's called, where it's still Disney properties. But Disney, I'm sure, works the same way. One corporation owns the land lease that the hotel is on. Another, whether it's called Radisson or Hyatt or whoever, manages the hotel. A third party contracts for the residential services. I mean, before you were done, there were 4 separate corporations that had to be named if you were going to, in fact, have to litigate it to the end, so that you didn't have someone at trial saying, "It's not me, it's Scott. It's not me, it's Fred." And that's not uncommon. That analysis has to be done at the outset, both to make sure you've got the proper parties, but also to make sure that the parties that I've got are going to be able to be around at the end and be able to satisfy this judgment. And especially, it's not just contingent, but on contingent, your entire fee will depend on A, success, B, making sure that someone's available to satisfy that judgment at the end. And that's not always a given. Even with millions of dollars at stake, you oftentimes have to say, okay, now how do I get to the next phase here? Because there's a couple of rules I want to bring into play so that you can think about it. We're supposed to do 66, 69, and 68. I'm also going to add 62 into it. I think we touched on it before, but I want you to take a quick look at it because it's something I want you to think about, because again, people don't oftentimes think about this aspect of it either. So now you've recovered a judgment, whether it's by way of trial, a summary judgment, or even a default. But more likely, we'll say it's by way of summary judgment or trial. But you know that that doesn't mean that that's the last word on it, because the losing party has the right to appeal. Rule 62 is the rule that comes into play as to whether there is a stay of execution on that, a stay of enforcement on that judgment. Just because you take an appeal, it does not mean that the winning party can't try at that point to satisfy and collect on their judgment. So unless you do something with respect to Rule 62, then the fact is, even if it's on appeal, the other side may be seizing assets and trying to satisfy the judgment itself. So when you look at Rule 62, it says, well, first of all, you can't issue an execution until 14 days after judgment. Not uncommon, just in case there are other motions and the like, as you could see from B. But again, these are sort of desperate measures at this point. But one thing I have the right to ask for, if I am the successful litigant, is a bond. If you're going to appeal, and there's going to be a stay of this judgment, then I want you to post a bond under Rule 62D. And then under those circumstances, the court can issue a stay of the judgment. Now, ideally, that's perfect for you, right? I don't necessarily want to have to go figure out how to collect this, what assets I have to seize. But if you post a bond, in essence, a sufficient assets, an insurance of some sort that for the amount of the judgment and the interest that should accrue on that judgment, then in the event when the appeal is finally resolved in your favor, I don't have to worry about a separate enforcement procedures. I have that bond that I can go against to collect. So Rule 62, you want a bond pending an appeal on the case. Because if you don't get the bond, now I'm waiting, and things can change over time. You know, just as illustrative of that point, we at one point rented the third floor out to Enron. They were going to do it from top to bottom, this beautiful facility, pay us a fortune. At one point, of course, they were like one of the third largest corporations in the world, too. Within months, they're out of business. It seems like it's a flim-flam, and you've got nothing. And financial fortunes can change quickly. So no matter how large the entity is, no matter what their present resources are, oftentimes you want to look for a bond pending appeal. Here's the problem. If they don't issue a stay, even though you have an appeal, even though you might have good grounds to succeed, when you get up there in a year or two and it's resolved, I'm going to start seizing assets from the time that execution issues. I'm going to seize your real estate and try and sell it. I'm going to seize the ships that you've got. I'm going to seize your locomotives. I'm going to seize it because the fact is, if I'm not aggressive with trying to satisfy that judgment, frankly, you're now in error. Because now you've got a paper that says you're entitled to it. If there's no stay at that point and there's no bond, you should be seeking means to enforce that judgment.
So, can you have the court appoint a receiver and attach, or at least prevent assets from being liquidated, you know, even in a fraudulent attempt to avoid, you know, the judgment or repayment of the judgment? Or is a bond enough? I mean, what?
If I've got the bond, then the bond, and they issue the stay, two things. So first of all, they issue the stay, and they can issue a stay. I think they've got to do some bond. No, depending on who it is, if you look at E, only against the United States or officers and the like, can they are they not obligated to? Under D, though, the bond is up to the court. It says may obtain a stay by supersedious bond. The bond may be given after the notice of appeal is obtained. The stay takes effect when the court approves the bond. The court could approve a relatively modest bond if they should so choose. But your question, though, actually lumped a couple of things together: the receiver, the attachment, and the like. And we're going to talk about methods of protecting that judgment in a bit. But if the stay is issued, you can't pursue any of those other methods. If they do not issue the stay, then attachment, the receiver, all of it is still open for fair game. Okay? You look like you've got questions on this? No? Winning isn't necessarily winning until I can put money in my pocket, right? And there are cases, and I can tell you a bunch of different stories where people recover the money. We had a guy who got injured with a ladder, and he wasn't our client at the time, but they came with the judgment and said, is there anything you can do on this? And the fact is, companies that make bad ladders don't stay in business long, and they didn't. And he hadn't found out who the insurance carrier likely was, so the fact is, it's horribly injured, but was recovering zero. But those other means of collection and enforcement of that judgment, you really have to start to think about, honestly, on day one. So 62 is that the court can issue a stay, but it's not automatic. And if you don't seek a stay, if you were the losing party and your client owes the money, then just because you take an appeal, do not think that there won't be any enforcement actions within the next year or two. They're going to be, as soon as that judgment issued, I'm going to start taking enforcement action simply because I can't afford someone else jumping in line either. Even if it's just simply a matter of priority of the lien, I've got to do something in order to protect and try to collect that judgment. Okay? Questions on that? So that's 62. If I've got the execution, one way of then moving forward with it is simply to give it to the sheriff and ask that real estate be seized and sold. Some methods I don't need to go back to court to do anything with if, in fact, I've got that execution. If property is out of state or out of that jurisdiction, then I may have to bring a suit on a judgment in the jurisdiction where there are, in fact, assets. That's one means of doing it. Another thing Freddie made reference to is Rule 66, which is receivers. And we looked at this in the Republic of the Philippines case. A receiver usually is used when the corporation owes money. And the receiver under Rule 66 has the power to take control of the corporation. In essence, they are the chairman of the board, the president, and everything else, and they can operate that corporation to the point where they can even liquidate the corporation if necessary to satisfy the judgment. So the appointment of a receiver, which requires a second action in superior court generally, and what you're asking then to do is an extraordinary remedy, if you remember the case. But what it says is that the court at that point can, in fact, appoint the receiver to operate the corporation, even meaning liquidate the corporation in order to satisfy that potential judgment. Very, very powerful, effective remedy, but also very extraordinary, if you remember the case. But the fact is, if you owe that judgment, demand has been made by the sheriff, and you failed to satisfy it. At this point now, the receiver is one way of enforcing the judgment. Seizing of the various assets that they have is another. We could seek attachment under Rule 4 by attempting to grab property as well and seize it. And by the way, we're going to look at the two cases, but virtually anything is subject to attachment. Attachment is, in essence, just a court-ordered lien on property. Okay? But virtually anything can be attached. The question is it worth it to attach? The easiest thing to attach, for instance, is real estate, because we get a real estate writ of attachment from the court when the motion is allowed. That attachment is given to the sheriff or the marshal and asked to be filed at the registry of deeds. They then see that the lien is there, and it preserves your place in line. So an attachment on real estate is the easiest, but I can attach wages, I can attach and seize your vehicle. I can put what's known as a keeper attachment in a premises where that's operated with incoming cash and receivables on a regular basis, and the keeper can take all of that cash and the like that comes into the store along those lines. I can attach and seize, and this is part of the problem. Items of personal property, oftentimes the way in which we affect the attachment, perfect the attachment, is by seizing it. And by seizing it, what that means is then it has to be held and maintained, and so storage becomes an issue. Even a storage of a motor vehicle, if you were going to seize it until such time as the court will authorize the sale of it and the like, you know, what do these tow yards charge you for holding the vehicle? Well, that's a car. What about a boat? Because all of those things could be seized. We had an occasion one time we were looking at seizing locomotives. And so the question was, how the hell do you seize a locomotive? And you know, the fact is you sequester it, you seize it. But then, well, what the heck do you do with it? Well, the fact is, the likelihood is by the time you're done, you've got a marshal or a sheriff standing by that locomotive until you're able to authorize the sale of it. Well, that can get pretty expensive pretty fast. Obviously, locomotives worth a lot of money too, though. So trains can't run without locomotives. So it's not just expensive. It's also a calculated gamble that it's got to be resolved.
One of the things that I seem to have trouble with is, let's say I have a judgment against a defendant for, say, $100,000. Do I seize assets up to $100,000, or do I just seize everything I can get my hands on? Well,
and I've used it as well. The notion of seizing is that word, and we use that word, but I don't know what context we're using it here. If I, attach and take his iPad, at some point then I'm going to sell it. But I can attach, I can attach all his real estate in Essex County, all his real estate in Massachusetts, even though he can come in and argue, well, it's grossly in excess of the $100,000 I allegedly owe you. Well, the fact is we're protecting the security at this point, and if the court feels that I've got a likelihood of success, and in fact there's no other insurance available, maybe they'll only allow the attachment on certain pieces or certain items. But the fact is there's no guarantee that those pieces he alleges he wants the attachment to be on are worth $100. And the fact is an attachment is not the seizure or distribution of it yet. It is just simply placing the lien. So it's $100,000 plus interest plus the costs that are due here. And so just to try and limit it to one piece may not be sufficient. So I want to argue that I need the attachment on all of the property. And then I'll pick and choose which ones have the most equity in that I will, at that point, or when it's reduced to judgment, ask the sheriff to seize. And that's when the seizure really takes place, when there is an execution and the court actually has issued that final judgment that says there's an order for this, seize it and sell it if necessary. But the problem with the argument about, well, how much can I seize? These are distressed sales. So no one's going to go in and pay you market value at any rate. I frankly might have to seize $500,000 worth of property and sell it to get a net result at a sheriff's sale of $100,000 to satisfy my potential judgment. Because people are expecting bargains, and they're also expecting, they understand that there's litigation that's part of this, and the title may be, it's obviously less than what I would get from someone else, especially with the issues of litigation that are likely part of this. So it's not as simple as saying, I'm going to seize Scott's home in North Andover for $100,000 and sell it, and I'm going to be all set. Because no one's buying, even if it's worth $100,000, if the broker would sell it in the ordinary course of business and all the rest, no one's buying it at a sheriff's sale for $100,000 because they're expecting a bargain. That's why they're going to take a risk with it.
You also want to make a point of grabbing, in the hodgepodge of assets you want to grab, you're sure you're grabbing the house that maybe he wants to sell next week. So if there's 3 or 4 houses, you get them all. You know, I mean, you might grab the one locomotive they don't plan on using for the next 6 months, it's, you're in trouble. If you can grab them all, they're not going anywhere until they sell.
And see, understand the aspect about you being in trouble. With real estate, it doesn't cost you anything other than to place the attachment on. If I'm holding even a motor vehicle, if I'm holding a motor vehicle at $30 a day, the cost can quickly outstrip any value that might be left in that vehicle, and that becomes a problem. So you've got to make an assessment of that. So personal property becomes much more problematic, but it doesn't mean that you won't do it. Bank attachments. The problem with the bank attachment is that unless you get it ex-party without notice to the other side, who among you are going to leave money in a bank if I tell you in a week from now I'm going to be seizing that bank account? If there's no order that prohibits you from moving it, and there's not likely to be, I don't even see it as unethical to say, no, you have no order that prohibits you from moving it now, and if you leave it there in a week from now, the court is likely to issue the attachment over that bank account. And what will happen then with the trustee process is that money is then segregated and held by the bank. I then move to charge the trustee to say, because they'll answer saying, yeah, we've got $5,000 of the defendant's money. I forget what the exemption is, but it's small. On wages and bank accounts, there's a certain amount exempt from attachment, but it's relatively modest, and the rest of the money would be turned over to the creditor. Was there?
I was going to say, isn't there some ethical obligation to, I mean, if to find that out, I mean, is there some sort of reprimand if you do that and you do take it out in terms of how you found out? Can you be held criminally liable or civilly liable for removing it?
No, it's not like a divorce case
Or
where
like insider
the
trading or
filing of the
something like
case prevents the transfer of assets. The fact is, this is an adversary proceeding where the creditor, unless the creditor is able to say, and I think the creditor oftentimes is able to say, judgment creditor is able to say, that if I notify them in advance, they're gonna move it. But that isn't really necessarily consistent with the due process cases. It's got to be sort of, in this case, we know that because of their actions, they will hide, conceal, destroy, and transfer it. But just, and I understand the concern about it, but the client brings you this motion for the trustee process that they're going to ask to attach your bank accounts at Citizens Bank a week from Friday. So you explain to them what that process is. Here's the question. Is there an order in place right now that prevents me from moving that money? So what's your answer? I mean, the answer is no, right? No, but I don't think you should. No, right? Because why not then? And no, but I can't? No. No, but I'm going to look bad when you and I go into court together. I mean, see, that's the problem with it. If there's no prohibition, and there's not likely to be, bank attachments, if they are not done ex parte, are likely to be very ineffective, simply because of the nature of it. Now, with that said, you'll be surprised. Some people will leave their money in the bank even with the notice, and you say, you're surprised when you catch anything when the motion's allowed, but sometimes it does happen. But I think more likely you've got to try and make the case why the attachment should be able to be done ex parte. And if you can show a judgment that hasn't been paid and the demand has been made and they're just not responding to any efforts, then you've got a shot at it potentially, getting a judge to agree to let you try it if you can show that they've got money there. But that's hard. That's not always easy too. With the consolidation of banks, it gets a little easier because there's fewer banks than there used to be. So you can sort of make some guesses and the like. Rule 66 is the appointment of the receiver we talked about. Let's go to 69 first, and then we'll come back to 68. 69 is a rule that people are not frequently aware of, but it's really 69B which becomes important. 69B allows you to obtain discovery in aid of satisfying that judgment. So what this means is that I can actually send out interrogatories on that existing case. I can do a deposition where the questions now in play are where are your assets, whose name are they in, what transfers you may have made, where the questions about assets and the like before aren't relevant on the issue of negligence or contract actions, but with respect to in satisfaction, in aid of judgment or execution, you can, in fact, obtain discovery in order to assist with that. The problem sometimes is you send out the interrogatories, you schedule a deposition, they don't show up, you say, what the hell, I'm not, I got no money anyway, I'm not coming, what can you do? Well, then you're going to have to seek sanctions like you would under Rule 37, if possible. But again, it shows again, as you start to think about how far down this road I'm going to go, it shows the court that you've attempted in many ways to obtain the information legitimately, and maybe that's why the court has to look at some type of extraordinary attachments like the bank attachment and the like, or the receiver potentially, right? So that's Rule 69, obtaining discovery in aid of execution, which again, a lot of people aren't aware of that. 68, another underused rule in my opinion. Especially for those of you defending cases, but for those of you that hope to do more plaintiff's work, it's important to understand Rule 68. And I think, and I know, Methuen had a problem with this case, with this rule. First of all, what does Rule 68 do? Rule 68 allows a party, the defendant, to make an offer of judgment. And you're better off making it earlier than later in the case, but as long as it's done 14 days before the date set for trial. The party defending the claim can make this offer of judgment, and in the event that the plaintiff ultimately recovers less than that amount, then the costs have to be paid by the plaintiff from the time forward from that offer, when that offer was made. To the extent that they want the offer, they simply accept it and the court will enter the order. But what it allows the defendant to do is to sort of shift this dynamic about each party paying for their own costs. In some cases, the argument can be made, are attorney's fees part of those costs? The general rule is the answer is no. But you can find some case law that would suggest it is, and I'm going to give you an example where it is. So, Rule 68 should be used more often because it really changes the dynamic of, should I try this case and am I at risk if I'm the plaintiff? Am I at risk of something if I do in fact try the case as I would like to? Because oftentimes the plaintiff, if the offer isn't sufficiently high to settle the case, the plaintiff risks nothing by going forward, right? I mean, you're offering me peanuts, you're offering me a few $1,000, I've got way more money than that invested in this case. I'll take my chances that the jury is going to be fair with me as opposed to taking your lousy good-for-nothing offer. Well, with the offer of judgment sort of changes the dynamic, because not only might you lose, but if you lose and you get less than that offer, you now owe the cost that the other side has incurred since the time the offer was made. And that's a hard conversation with some clients because it's a real bitter pill to swallow. Okay, so not only might I not win and I come up with 0, but if we come up with less than what they're now offering, then I owe them? And the answer is yes. And that's a little cold shower for some folks. But that's why I think defendants should use it more often than they do not.
The plaintiff owes the defendant?
I'll give you, I had a two-defendant case, and it was a real screwy, it was a horrible result for the plaintiff, and it was an auto accident case, but it was sort of this whole pinball situation between two cars that got into play, and the plaintiff was horribly injured. But the two defendants, our argument is they're joint and severally liable for the way in which the accident took place. They hit up here and then sent one spinning into my guy, my girl. the one that caused the accident up here is not the one that hit my girl and caused the horrible injuries. And so in essence, that one's arguing, what the hell? Other than not being on that road, what could I have done to avoid this? Because I'm not at fault for the first sequence of these events. But clearly is in the wrong lane when she hits my client, okay? That's an interesting case if you think about it, because if the jury wants to believe that this horrible chain of events was put into play by the first negligent actor, they might come back and say it's all on that person, none on the second driver. And so, in essence, it's a good case to try because we've got two defendants pointing their fingers at each other, and we've got big damages, so it's a case you're likely to try unless they put sufficient money on the table anyway. But what the defendant who's less culpable does, probably about 3 months before trial, and actually they didn't push it as often as they should. They made an offer of $50,000. Now, $50,000 is not nothing, obviously, by anyone's stretch of the imagination, but it's not enough to resolve the entire case. And if it's a joint and several liability case, the damages are likely well north of $500,000. So the challenge is you don't want to let off a defendant who's got policy and enough liability insurance to satisfy those types of damages off of 50. But the risk is you try the case. I could either come back with realistically, it could be a 0 verdict, or depending on how they apportion liability here, if they decide to do that, it could be 50 or less. And so we have to have a conversation with the client, recognize, and again, 50, we maneuver some of the meds around and the like and work on the second half of the case. She could even come out with cash on the first part of it. So well, the conversation has to be, listen, they made an offer of judgment. There is a real possibility you could come out with less than 50 from this defendant. There's a real possibility that the verdict could be a defendant verdict for that defendant. And then you owe them all their costs incurred from that date forward. And one of the costs would be the accident reconstruction expert, who was not short money. He's very, very good. Ours was even better. But theirs wasn't bad. But that's not short money. And that's not even attorney's fees, but we're talking a fair amount of money. So the question had to be, what do you want to do? And that's the way an offer of judgment works, is we had to have a real conversation about you could get less and you might owe if you choose not to take it. And also the other part of it as well, 50 isn't nothing. Let's think about it. We still have a defendant left who I do believe was more culpable to begin with. I mean, they're the ones that set the whole thing in motion.
But aren't you, by that offer of judgment, are you acquiescing to some sort of guilt by that offer, though? I mean, because, isn't it a causation question? Like you said, the first car was far more culpable. The only way that person could have avoided it is simply not being there then.
Well, it's not guilt, but the problem is, I've now given, suppose it's Fiona and Scott, and Scott's out for the 50. I've now given Fiona the ability to argue at trial. Me, I didn't even touch her car. The person that touched her car isn't even here today. And that's the analysis you start to make, is how does this play out as we try it? Because if I were trying her case, that's exactly the way I would try it, is what the heck? Because she really was probably at least that other piece of it, not at least, about 100 yards down the road is where that accident, that portion of it happened. And it just spun his car around 360 a bunch of times till he hit the other girl who was happened to be my client.
What happened?
She took the 50,
She did.
and we settled before trial against the other for significantly more. But you don't know that at the time, because they were arguing, they were saying they aren't going to pay a dime, which they always say, that's what they say. So she took the 50. I think it was the right thing to do as we worked through it, because I could see it as a case where I'm not sure it was jointly and severally. The more I could see, we had two independent tortfeasors at work here, and she really is the one that set this whole horrible chain into motion. This person, other than being pinballed really into our car, couldn't do much. but the rule of the road says he still should have been able to control his vehicle, which he didn't. So it was a good case. It was a horrible result for her, because she really was very seriously injured as a result of this. But I think, and I do think that that was the right way to go with respect to the offer of judgment. What I don't understand is why defendants don't use it more often. Because even in that case, it was open for a long time. He kept saying, why don't you just take it? And it took a while to convince us, as we were finishing discovery, that there was some risk that if she didn't, that there was some exposure. And what makes sense here as you look at offers of judgment is it requires a much harder assessment of your case, and I would think it should be used more often. I've had cases more recently. I had one 2 years ago. I really think absolutely they should have made an offer of judgment, and it would have made it a lot more difficult to keep going further if it had been substantial, but not as substantial as I would have liked. They would have made a better case, I think, for saying, you could come out with less than this number. Because again, if you try cases, you don't know necessarily what they'll do. And I think it gives the defendant some leverage here. But they don't tend to use it as often.
But they may make an offer, but they
Oh,
don't.
we can make an offer anytime, right?
But, no, but they don't attach this rule.
No, this is a formal offer under Rule 68, and it has to be described as such. And if you look at the rule, there's got to be a certain time, 14 days prior to trial, and then you have 14 days from the time you get the offer to either accept or reject it. And if it's accepted, and here's just so we can understand, because this, well, it was in the paper. 1983 action, civil rights action against a town, we'll say, okay? Defendant makes an offer of judgment. Defendant says, we'll give you $200,000 in judgment, whatever it is, just say $200,000. Plaintiff says, okay, we'll take it. They file the formal offer of judgment. And what it says here is then that becomes a judgment. The judgment is entered by the court, okay? Well, the way 1983 actions work is that if you are the successful litigant, you are then entitled to attorney's fees for all of the attorney's fees spent from the time you started with the suit all the way up until the time of judgment. And so the town accepted the offer of judgment, I think, unwisely, because unless, at least by formally doing it this way, as opposed to saying, listen, we'll give you $200,000, but we want general releases, blah, 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 blah. They allowed the offer of judgment to enter, and then what the plaintiff's saying is, okay, I'm a successful litigant now. I've got a judgment for $200,000. I want an assessment of attorney's fees. And even at $200 an hour in a 1983 action, you might easily have 1,500, 2,000 hours into that case. And this case actually had been litigated extensively. So the number was, well, what's even if it's say it's 2,000 hours times $200 an hour, that's $400,000, right? I think if I did the math right, isn't that right? So the plaintiff's now saying, okay, listen, give them the two, but I want $400,000 plus two, because the $400,000 would be an appropriate award of attorney's fees. You got to be really careful about that, because the plaintiff is the successful litigant under Rule 68 on any offer of judgment. You have an offer of judgment that I get $10. I'm now seeking attorney's fees. And so that's one risk for a defendant to accept this offer of judgment, to make an offer of judgment, because if accepted, the plaintiff is then the successful litigant and entitled to attorney's fees as well. And attorney's fees in a lot of these cases are far more than the claim itself. Go ahead.
If the agreement was a contingency with the attorney, how are those attorney's fees assessed?
No, see, that's, okay.
Because
Yep.
most likely it was a contingency basis, not,
I
no one's going to
agree.
pay
I
$400,000 to the attorney to collect $200,000. So how does that work out?
Well, my arrangement with my client with respect to how the bulk of my fee will be paid is between my client and I. So I can take Scott's case on a contingent basis. But if I'm taking it on a contingent basis in one of these areas where there are statutory awards of attorney's fees available, discrimination, civil rights, those types of things, and there's a lot of them these days, okay, a lot. Especially your claims of discrimination, your whistleblower suits, there's a whole bunch of different areas, okay? But that doesn't mean that simply because I take Scott's claim on a contingent basis, that we don't also have a claim for the hourly fees recoverable under the statute if in fact we're the successful litigants.
So if you're successful and you recover attorney's fees, who gets them? The attorney or the client, and then you get your contingency fee based on that recovery?
Okay. Here's the, well, first of all, I'll give you the law, and then we can talk about how you do it. The award itself is also part of the plaintiff's damages, and it belongs to the plaintiff. The plaintiff can contract with the lawyer for how he would like to do it. Now, this will sound grossly excessive to you, but I'm going to tell you it anyway, because it asks me. He can agree to pay me a contingent fee. He could also agree, potentially, that award of attorney's fees, if in fact it has to be made, either we will split, which is oftentimes done, or will simply belong entirely to me as part of the additional compensation. And no, the reason is this, okay? Just to be frank about it, because it sounds like a real windfall. But if I have to take, or if anyone has to take that case to trial, that's an enormous amount of additional work over and above settling a case. And so, and the fact is, that's a strategic decision by the defendant to make it that difficult and expensive so you'll walk away. So, in essence, the lawyer can get both then a contingent fee on what we recover, plus the award of attorney's fees can, by contract, as part of the fee arrangement, can belong to the lawyer as well.
So the lawyer could end up getting $466,000, where the plaintiff got $133,000.
That's correct.
He's probably,
That's the way you do the math.
he's
right?
probably
Those are the
already,
cases you look for, though,
he's
right?
probably already got the case anyway.
It seems like a windfall. I mean, it seems like, you know, the Board of Bar Overseers would call that a windfall, you know, to the attorney.
Yes, I'm not, yes, but, you know, the fact is, on a lot of those types of claims, 1983, your serious discrimination claims and those, the attorney has at least as much invested in the claim at some point as the client. And honest to God, if you're going to take that to trial, those are not something you prepare, you know, like you're going to go over here for an hour and a half. Those are months of likely intense preparation and some investment of your own capital as well. When you look at the numbers, it sounds excessive, but for us to have to go all of that way to trial and then recover the judgment, then collect on the judgment, that's a lot of work. And it's an enormous amount of work. But I'll tell you, here's where the bigger problem, or not as big a problem, comes in, okay? He's comfortable with the two, right? He says, I'll take the two. We're negotiating the same. I'll take the two. Use the same hypothetical we've got. I've got 2,000 hours in. I think I can win this case. Modest hourly rate of $200. If he takes the two, and we settle it, and there's releases and nothing else, I get 66 grand. And again, I'm not dismissing that. That's not nothing, okay?
Well, for 2,000 hours, it's not much.
Well,
right?
well, that's correct. I don't know what the math was. 30 bucks an hour? 30 bucks an hour, right? You guys get details paid more than that, I imagine, right? But that's right? So it's 30 bucks an hour. So, but here's the problem, and we've talked about this before. It's still his case to settle. And I have an obligation to make sure that I do right by him, even though, as I'm sitting there doing the math, I'm sitting to myself, don't say it. Because really, right, I mean, the difference is, as you already pointed out the math, the difference is 466,000 versus 66,000.
Couldn't you argue that's your professional discretion to do that, even though, you know, I mean, it's better for you?
Let me answer this, because
That's an ethical question.
I've actually been in this position. How can you not do anything other than tell him to take the 200?
You
If
can
200,
tell
what?
them, hey, there's a chance we could get another 400,000 and I'll split it with you.
Well, and that's the
I
argument.
propose that as a contract to them,
That-
because if we win this claim,
That's
by
the argument
law,
for why you want to
I
split
can-
those attorney's fees as opposed to have them go one way. Because if they go one way, There is no incentive, if they're offering him the 200. You saw this in Serrano versus Priest first year, where they offered the plaintiff everything he could get at trial. And he took it, as he should. And so if everything he can get at trial is 200 grand, and they're saying, Scott, here's your check, 200, here's your cash. You don't even need to go to the bank. Here's 200 grand right now. You should take it. How can your ethical duties be anything other than to say, Scott, you need to take that money, right? Even though the personal loss to you is significant.
No, I would say your ethical duty is to point out to them all the potential avenues of recovery, which would include.
So we got to, but that's what you're saying, and I think that's right. We've got to negotiate a different deal.
You're never going to get in the trial. You're never going to get more than that 200,000. But because
but I can make a deal with you today, Scott. Doesn't sound kind
But
of.
is there potentiality?
But the whole thing sounds
Fair enough.
Is there potentiality you could get less though? There's a potentiality.
Yeah, and don't think that someone wouldn't suggest that. Yeah, guarantee me the 200 either way, and I'll go with it.
Yeah, I was gonna say there's always the potentiality that you're getting less than that too. So
That's fair enough as well. Here's the problem with the 1983 or any type of actions with the attorney's fees as part of it. This becomes, and you haven't always thought of that at the outset. It's something that you need to think about because it has to be contained in the fee arrangement up front. And makes a lot more sense if it's done at the outset than all of a sudden we're on the eve of trial and hey, we've got to talk. I never thought we'd have to go this far, but here's the deal, and I want those attorney's fees. Or what, right? Or what? Because you're trying that case no matter what.
Right.
And frankly, the rule is, absent the agreement, they belong to him. They're part of his damages.
So that's why you would want to split it up front, because then you'd have to tell that option to the client, right?
Splitting it up front means that he's got, I'm not sure, it's not supposed to say dog in the fight anymore, right? Means that he still has an incentive as part of this transaction.
So you'd have to tell him that though, right?
Yes.
When he's asking you if he should settle.
Well, I said you could get attorney's fees, and our attorney's fees at this point are significant. And under our contractual arrangement, you would get half of those. Oh, by the way, some of them, you get all of those, right? It's not automatic, and it's a question of who they belong to, and then there has to be a separate fee award, and oftentimes, by the way, that is more litigation. In some cases, a lot more, because they're going to contest how many hours you put in, what you did, whether they're reasonable, and whether your rate is reasonable. But sometimes in some of these actions, they become really quite problematic. I had a conversation with the attorney up in Portland about 2 years ago. We had similar defendants. And their actual damages were relatively modest in this case. Mine were significantly different, but theirs were relatively modest. But what they were saying is, we can't settle this case at this point, even though her damages are modest, because the attorneys, they won't agree to dime one on the attorney's fees. And the attorney's fees, I'll give you the numbers because it doesn't matter. I think they were saying their damages they thought were around $45,000. The attorney's fees, having taken the discrimination claim, and legitimately at this point, were north of $150,000. And they wanted those fees back because that's how they were being paid. They didn't want a third of 45. That wasn't their arrangement. Their arrangement was they would get the hourly fees that the court would ultimately award, which, by the way, gives them an incentive to make the case go to trial then, too. So this somewhat problematic both ways if you work it through. We've got to do these couple cases. You have other questions on that?
So when you have a 1983 claim, there's no way.
It's not just 1983.
Or
All
any
harassment, discrimination claims. There's a lot of modern statutory.
Okay. Any of these type of claims.
93A.
Not right. Any of these. There's no way if you make an offer of judgment to avoid paying the attorney's fees on these type of claims.
Not by way of an offer of judgment, and that's what you've got to be careful about. They got really stung over here on that because if it's an offer of judgment, you're the successful litigant. And I looked it up in the paper because I saw what not the paper, I researched it because town council saying, no, that's not the way it works at all in an offer of judgment. I'm thinking, no, that's precisely the way it works. Law students would know this. And I think it's clearly a mistake.
What's the incentive for a defendant to do an offer of judgment as opposed to a settlement offer?
Well, I've offered you that 50 grand. You told me to go to hell. You want $500,000? I said no. 50 grand is tough. And again, like I said, that's not nuisance money. That's someone is placed an assessment on the case. And you said, no, go to hell, I'm not taking 50. And until until he and I have to have the conversation about this cost coming out of your pocket in the event you get less than 50 from that defendant, it's easy to simply reject it. But now when I have to tell him, not only could you lose against that defendant, but you may have to give that defendant.
So that's the incentive for the.
5 to 10 grand. It's a different analysis, right?
Right.
And in some cases, you'd argue maybe attorney's fees are attached to that as well, and then that's a huge number if we can somehow make that argument. But that's the incentive, is to do it, to try and avoid it. I push those people down in Rhode Island. I kept saying, make an offer of judgment. Make him understand that I want our costs back, your costs back. I want the reconstruction expert. I want him to know that that's the risk in moving to trial on this. And again, if the number is right, it has to make you make an assessment. If the number is, nuisance value, 2, 3, 4 grand, 5 grand even, you say, I don't know, I think I've got a chance of doing better than that. In a case like the one I described to you, where you really have, you could have one defendant liable, you could have the other defendant liable, or you could have both of them liable. Those are really the alternatives. I didn't see a no liability. But there was a risk that one defendant could escape scot-free. Let's talk a little bit about digital equipment, because we also haven't seen RICO much. And RICO is another federal statute where attorney's fees are authorized. All we have to do is show 2 predicate criminal violations, which these days, we tend to think of mob violations and the like, but it doesn't have to be that. My guess is there are a million different ways over the internet to create various violations of federal law that would allow you to have a RICO action that one could pursue. And the list of attorneys in this case, when you see it, are some very well-known both criminal defense lawyers in Boston with a long track record of success. When I was in Boston, a lot of these names were ones that you saw often with the biggest criminal cases, but this is a civil case. And here what they're doing is they're seeking an attachment, and it's a significant amount here, but it's because of what was done to digital, but they want a $300,000 attachment on the property. And in doing so, what they're trying to do is hold that property during the pendency of the litigation, hold their place in line so that when they do obtain judgment, they will then be able to obtain an execution and then give the execution to the sheriff and tell the sheriff to sell the real estate, assuming there's equity there. And the priority goes back to the time of attachment. So a piece of litigation, especially a piece like this, could take you 2 or 3 years easy to litigate. And there may be other people, other creditors coming in the meanwhile. So oftentimes we will seek an attachment under Rule 4 and 64 in order to try and preserve that asset while the litigation is pending. And it's wise to do because, again, litigation can take quite a while and people's financial situations can change. What it says here on page 20 of the original decision is Federal Rule 64. The Massachusetts law controlling the procedure for motions for attachment is located in Rule 4.1 of the Mass Rules of Civil Procedure. To enter an order approving a real estate attachment, the court has to find the existence of a reasonable likelihood that the plaintiff will recover judgment in an amount equal to or greater than the amount of the attachment, over and above any liability insurance known or reasonably known to be available to the defendants. So we're using both Rule 4.1 as well as Rule 64 when we start to think about what an attachment is. And it's not the injunction standard here. It's a very easy standard. Reasonable likelihood of success on obtaining this amount by way of judgment, and that the defendant can't show any insurance, or sufficient insurance, I should say, available to satisfy any potential judgment. And so even if it's a motor vehicle case, and they've got a policy of 2040, we'll just say a $50,000 policy, If the damages are likely to be $200,000, then even where there is some insurance, the court can authorize an attachment over the amount of the insurance. So in essence, if it was over 50 and the amount of damages could be as high as 200, the court can in essence authorize an attachment on your property for $150,000. One way to avoid attachments on your own properties and the like is to create a homestead declaration on your houses, which is something you should do if you have not already done. The cost is simply a filing fee at the Registry of Deeds, and it protects that the equity in your property from attachment of this sort. Not going to protect $300,000 worth, $300 million, $3 million, but it will protect hundreds of thousands of dollars from seizure along these ways. Another thing that's mentioned on this page 20 that I want you to look at, because my civil procedure teacher didn't talk to me about this at all. If you look at footnote 2, it talks about, and this is in federal court now, it says, without elaboration, without providing this court with a memorandum in support as required by LR 7.1A1. However, the Curry defendants state they have a good defense of this action as reflected in their answer. L.R. 7.1A1 stands for local rule. In the federal court, when we go there, we don't just use these federal rules of civil procedure that you looked at during the first year of Civ Pro. In addition to these rules, like in addition to the Massachusetts rules of civil procedure, there are specific rules for that court. These are called the local rules. And that will govern the font size of your briefs, the requirement in this case of a memo in support of any motion. It will requires that you and your adversary confer before filing any discovery motion. There's a whole host of them, local rules in the federal district court. And wherever you are, whatever federal court you're practicing, you need to be familiar with them and comply with them. Because if they're not complied, the court is simply going to send you back whatever it is you filed without hearing or any further question, simply because you didn't comply with the local rules. So it's not enough simply to do what the federal rules of civil procedure says. You have to do what the local rules require as well. And we left law school, and she hadn't talked about it at all, and then Judge Wolfelsworth in the federal court wanted to know who among us knew what the local rules were. And so the first opportunity I had in federal court, I lied and raised my hand and said yes. I hope that's where the inquiry would end. But so you now know what the local rules are, and you're going to look at them when you are thinking of practicing in federal court. The other thing to be familiar with now is, and I've said this to you before, most papers in federal court are filed electronically, and there is a whole process that you need to become familiar with in doing it. It's free to become familiar with it. At some point, you set up an account online. And again, as I was tracking down this corporation yesterday, I said, you know, I ought to look and see when they've been sued before, or how they've described themselves as to where their principal place of business is and state of incorporation. And I also ought to see if there are other employment issues out there that maybe there's a couple of good complaints that I can steal a little bit of good stuff from. So it's actually one way now, the more often that you think about, it's a good tool to investigate the various electronic filings, both that are against the entities that you're thinking about as well. And so I would encourage you to do that as well, because I think there's a lot of information there that before we never would have been able to get access to any of this. You read this case. I thought it was an interesting case. It talks a little bit about RICO as to how you would succeed on the RICO claim, but it really is here for you to look and see how that attachment works and what the standard is. The likelihood of success standard is relatively low, and so what they're trying to do here is seize the property. The argument being that Digital lost a lot of money, and at one point Digital was the Apple of its times, I guess I'd say. And they wanted to obtain the money that they had lost in this process. Again, the end of the case makes reference to the potential of posting a bond in order to oppose the attachment, and that's one way as well. And again, you don't necessarily care what form of security is there. you do. You want to make sure the security is legitimate security. But as long as there's something there in order to satisfy your judgment at the end of the line, that's ideally what you're looking for. The last case, this aviation versus RSBI Aerospace, is in fact the appointment of a receiver over the corporation, and as it says here, to in fact liquidate the assets of the corporation. If you look at the little history here that's recounted, there's an awful lot going on where they're trying to get information or get payment, and they're not having much success with either. And so the appointment of the receiver, as the court saw here, really is sort of the last resort. But the fact is that you leave the court with no other alternatives, then that's precisely the way it will resolve. And that, in fact, is what they ultimately did here. While it is an extraordinary remedy, it was the only remedy that the plaintiffs were left with. And ultimately, that's likely to mean that either the defendant now will find the assets to pay, or the corporation and its assets will be liquidated in order to satisfy the potential judgment of the plaintiff. So I thought this was an interesting case to look at and to think a little bit about, because the fact is, they don't all end with simply the jury telling you to win. You win, and then the defendant immediately gives you a check or payment of some sort that will be sufficient. The fact is that oftentimes we have to take other methods in addition to simply obtaining the judgment in court in order to satisfy our judgment. One last thing for you to think about. We saw it in the Anthony's Pier 4 case. Oftentimes, before you ever then get to the judgment, and you've got your money and you're going to execute, some defendants will have tried to hide, conceal, or transfer their assets, either through trusts or straws or the things we've seen along the way. And there are statutes that allow you to go in and try to transfer back assets that have been fraudulently conveyed in order to avoid payment of the judgment. It's a more consuming process where you're going to be in superior court. You're going to have to show that the statute's satisfied. I can't remember the statute offhand right now. But what in essence you're saying is either the transfer has rendered them insolvent, or it was done with the intention to defraud creditors at the time. And so in essence what you want is you want that piece of real estate. Either you want a constructive trust over it, or you want to transfer it back, and the court can in fact order that the property be transferred back and then seize it and then sold. And that's, if you remember, that's what they did in that Pier 4 case, where he transferred it on the day he filed the complaint. At some point then they got an attachment over that real estate in order to be transferred back so that the creditor could take advantage of it. So these are all various remedies that are in play. They're not equitable remedies per se. They are simply means of trying to secure satisfaction of the judgment that you've obtained. The best advice I can give you is do it at the outset as you start to think about filing the claim, making sure that we've got the defendants there and there are means that we can use at the outset that will preserve those assets so that when we do and are able to obtain judgment, that will be successful. The other part of it gives you is some leverage. And it doesn't have to be an attachment per se. Maybe it's simply an injunction seeking the defendant from not being able to transfer assets beyond the ordinary course of business or something. And that would carry with it the sanction of contempt. We brought an injunction one time trying to prevent them from further alienating this an invention dispute and the like. And while we were not successful at the time getting the injunction, what it was able to flush out is the money stream and where things were going and how, in an affidavit that ultimately proved very damaging to them with respect to the facts of the case. And so sometimes if you stir things up and try to make things happen, good things can come out of it. But you've got to think at the outset of how I'm going to protect these assets, because a lot can happen in 2 or 3 years as the case is pending. Questions on post-judgment remedies or pre-judgment remedies? Attachments, receivers, rules 62, 64, 66, 68, 69.
So we don't have class on Thursday.
No, but you're supposed to go to the pro bono seminar.
I'm just saying, okay, cool.
Yeah, go ahead.
What should I do on Monday, the 14th? Should I just come to your office at 4:06? Because I have to take the exam on Monday.
Yep.
Where's the seminar? Oh, it's just out there.
Where's what?
Where's that going to be?
The seminar?
Yeah.
208, right across the hall here, and there'll be refreshments. And then tomorrow night, for those of you that are in the building, we're having a brief ceremony, talk about the advocacy teams and their success and to recognize our seniors. Yes, and there'll be adult refreshments, sir. Yes.
And just about the format of the exam, just review some prior exams as to the format.
Yep.
Definitions and possibly a fact pattern.
Have me for Civ Pro?
Yes, sir.
And yet, it doesn't look a lot different from that. And look at the old remedies. I'll tell you what I'm going to do. I had made a midterm. None of you decided to take it, so I'm going to expand it, and that's what we're going to do. So it's half done already. So
That's available online, the midterm?
Nice try. I better check that though.
Hopefully there's a mix-up like the other one. Let's hope that's checked out.
If you look at last summer's exam, last exam, the format, my format for the last number of years has been very similar for remedies. Well, no, evidence is a little different.
But you always throw a curveball at us. There's always.
I gotta be have a curve. They can't. I want to make
There's a
sure
little
you challenge.
curve.
Professor Malagudi's helping me write the exam this year.
Oh, no.
With the 80 pages?
Go over the cases, look at the questions I posted. I'm not going to come at you from left field. I want to know you know. When you do have whatever the problem is, don't just sort of jump in and give me, a 3-page solution. I would like to know that you can put Civ Pro and torts and contracts and injunctions and equitable relief of various sorts and whatever else is in there together, and I can read your 6 or 7 pages and say this person gets it, so that when they leave here in a semester or a year, that I can feel comfortable that you might actually be able to practice law. So, but don't leave the points on the table thinking, oh, he knows all of this already. Write it like you're writing to someone who hasn't taken the class. Okay? Good luck.